Thank you. Good morning. The Committee on General Government Operations, Federal, Foreign, and Regional Affairs now convenes this hearing. For the record, today is Wednesday, July 18th, 2018, and the time is now 10:06 a.m. In accordance with the Open Government Law, public notices for today's proceedings were provided to senators, stakeholders, and our local media. A 5-day notice was provided on Wednesday, July 11th, 2018, and a 48-hour notice was provided on Monday, July 16th, 2018. The public notices were also published in the Pacific Daily News, the Guam Daily Post, and the Guam Legislature website. Today we will hear and accept testimony, both oral and written, on the following items. We will hear them also in the following order. First, we have Bill 279-34, introduced by Senator Tomas C. Ada, an act to amend sections 5110, 5111, and 5112A, all of Chapter 5, Title 5, Guam Code Annotated, relative to the General Service Agency and the Chief Procurement Officer. Second on the agenda, we will hear Bill 303-34, introduced by myself, Senator Michael F. Nicolas, an act to repeal sections 10103 of Chapter 10, Title 4, Guam Code Annotated, and to repeal sections 5103 of Part A, Chapter 5, Title 2, Guam GAR, Guam Administrative Rules and Regulations, relative to allowing investigative, intelligence, or security employees of the government of Guam to be represented by employee organizations under the Public Employee Management Relations Act. Third on the agenda, we will hear Bill 272-34, introduced by Senator Telena Cruz Nelson, an act to add a new subsection E to Section 6303 of Article 3, Chapter 6, Title 4, Guam Code Annotated, relative to requiring reporting of amended government positions and deferring the filling of amended positions. Fourth on the agenda, we will hear Bill number 219-34 COR, introduced by Vice Speaker Therese Terlaje and Senator Dennis G. Rodriguez Jr., an act to amend sections 40112M, Chapter 40, Title 5, Guam Code Annotated, and add a new section 4112T and a new 40112U, Chapter 40, Title 5, Guam Code Annotated, relative to authorizing mayors to offer veteran status data on verification of residency forms, include the solicitation of veteran demographics in their annual census, and conduct semi-annual community outreach efforts to verify the veteran population in their jurisdictions for the purpose of updating the Guam Veteran Registry and connecting the Guam veteran population to available services. And last on the agenda, we have Bill number 292-34, introduced by Senator Dennis Rodriguez Jr., an act to add a new section 43121 and 43122 to Article 1, Chapter 43, Title 5 of the Guam Code Annotated, relative to allowing the use of video teleconferencing applications at meetings of government boards and commissions to guarantee quorum for convenience and to expand eligibility of membership to those community members that may be homebound, and relative to the use of video live streaming at meetings in order to increase transparency in the government. I'd like to take a moment to acknowledge my colleagues who have joined me this morning. To my immediate right is Senator Tom Ada. To his immediate right is Senator Telena Nelson. To my immediate left is Vice Speaker Therese Terlaje. To her immediate left is Senator Dennis Rodriguez Jr., and to his immediate left is Senator Will Castro. Thank you, colleagues, for making today's public hearing. So first on the agenda, we have Bill number 279-34, and I'll yield to Senator Tom Ada for his opening statements.
Thank you very much, Mr. Chairman. Mr. Chairman, Bill 279 is basically an act which addresses the relationship between the GSA, the General Service Agency, which handles the procurement activities of Government of Guam, and the Department of Administration. As it stands right now, what the law stipulates is that the Chief Procurement Officer really has plenary authority over all procurement transactions, and is really not accountable to the Director of the Department of Administration for any other matters, management or for general accountability. So what Bill 279 does is it preserves the independence of the Chief Procurement Officer insofar as getting the procurement transactions through according to law but places the Chief Procurement Officer to be accountable to the Director of Administration for Management and Administration of the Office of GSA. And this bill was brought up as a result of a recent audit by the Office of the Public Auditor. And basically, the Public Auditor has noted that on previous audits, deficiencies had been noted. The Chief Procurement Officer basically dismissed it or had a different opinion, and it ended there. And so basically, then Bill 279 would put GSA under the oversight of the Director of Administration.
Thank you, Senator Atta. To testify on Bill 279-34, we have Mr. Edward Byrne from the Department of Administration. Sir, you may approach. Go ahead and turn the mic on, and you can begin at any time. Thanks, Ed.
Senator Sir Nicolas and Senators, Bill 279, introduced by Senator Atta, has a single objective of placing oversight of the Chief Purchasing Officer's actions and accountability for the outcome of audits with the Director, Department of Administration. It seeks to normalize the current definition of responsibilities, which are currently inconclusive. The General Service Agency is a division of the Department of Administration. As such, the outcome of performance audits carried out by the Office of Public Accountability or single audit reports submitted by independent auditors on matters relating to the central purchasing activities of the Government of Guam are referred to the Department of Administration. DOA, as a result, is tasked with resolving any issues raised to prevent recurring comments in subsequent years' reports. This bill clarifies and clearly states that the Chief Procurement Officer has full responsibility for the methods and practices for the supervision and procurement of supplies and services, and will be accountable to the Director of Department of Administration for his or her actions and the results of those actions. Thus, any weaknesses reported by auditors can be addressed within the financial management framework of DOA and corrected. The bill clarifies an opinion of the Attorney General issued many years ago, which defined, because of the uncertain wording of current legislation, the duties of the CPO vis-à-vis the Director of DOA. The clarification introduced by this bill will enable both managers to improve procurement processes and obviate any further adverse audit comments. It makes clear each of their respective responsibilities, and in particular, that the Director should not intervene in the procurement process for daily purchases, but should establish policies consistent with statutes and regulations for CPO to carry out. The Department of Administration supports the passage of Bill 279-34. Thank you for the opportunity to come before you. Please let me know if you have any questions.
Thank you, Mr. Byrne. Senator Atta, any questions for? Do any of my colleagues have any questions for Mr. Byrne? If not, thank you very much, sir.
Could we get a copy of that AG opinion that you were referring to? Or do you have that, Mr. Chair?
Yes, Senator.
Please, and which part of the bill is what you say going to clarify that AG opinion regarding authority, I guess?
Well, I think what I intended by that was that the AG opinion was interpreting the previous statute. This statute makes it much clearer, and therefore the AG's opinion is no longer required.
All right. This allows the Department of Administration to do a different procedure in establishing the position, but what makes the position answerable to the department? Is it the prior sections of 6303 that aren't in this bill? Maybe I need to see that. Sorry. When you said they would be accountable, in what? Yeah, just if you could just point that out.
Senator, it's in the new section 5110. It says the Chief Procurement Officer shall be accountable to the Director of Administration for management and administration of the Office of the General Services Administration.
All right. Okay, thank you.
Any other colleagues have any questions for Mr. Byrne? Thank you, Ed. Just for the record, we do have a written testimony that's been transmitted by the Office of Public Accountability. They just made a suggestion to correct a reference of the General Service Administration to instead refer to it as the General Services Agency. But it basically is a restatement of what the bill is intending to do. Thank you. We also have written testimony that's been transmitted for the bill by Mr. John Thomas Brown, and that will also be included in the record for today's hearing. There being no further individuals to testify, we'll go ahead and conclude the hearing on Bill 279 and regard this bill as being duly heard. Next on the agenda, we have Bill number 303-34, introduced by myself, Senator Michael F. Q. Nicolas. This is an act to repeal Section 10103 of Chapter 10, Title 4, Guam Code Annotated, and to repeal Sections 5103 of Part A, Chapter 5, Title 2, Guam GAR, relative to allowing investigative, intelligence, or security employees of the Government of Guam to be represented by employee organizations under the Public Employee Management Relations Act. The purpose of this bill is to remove provisions in the law that are currently prohibiting or are being used to prohibit our law enforcement officers from being represented by employee organizations under the Public Employee Management Relations Act. Just to be clear of what that all means is, right now, for example, in the Department of Education, we have our educators who are represented by an employee organization under the Public Employee Management Relations Act. Our teachers, our educators are able to, through this representation, collectively bargain, have their interests represented, and fight for certain things that are good for the department and good for the system. For example, teacher schedules and classroom sizes, the kind of things that are necessary for us to have a well-functioning school system that's going to be servicing not only the members of the employee organization, but the school system at large, because it helps for a more effectively managed classroom, a more rested teacher, a teacher that's more able to handle the demands of the job on a daily basis. Having that same kind of employee organization representation for our law enforcement officers will go a long way towards helping our police officers be able to collectively bargain for such things as more reasonable schedules, shifts that are more sustainable, also certain workplace standards, like certain amounts of training that they should be receiving, certain amounts of equipment that they should have, the readiness of that equipment. And so by passing Bill number 303-34, we will remove these restrictions that are preventing our law enforcement officers from being able to come together and be represented by an employee organization similar to the way our teachers are. And if we're able to allow them to do that, I think that that will be a huge help for our law enforcement officers to be able to make sure that those who are really manning the stations and are the boots on the ground, they're all going to be able to have the work conditions and the tools and resources necessary for them to most effectively do their jobs. And so we're hoping that we can get some good testimony on Bill 303 and some perspectives with respect to the intent of the bill. Signed up to testify, we have Richard Kress, Andrew Kittigwa, Chief J.I. Cruz, Mr. Robert Koss, and Mr. Dan Del Priori. You can all please join us at the table. Chief, we'll go ahead and defer to you, and you can go ahead and begin today.
Manana Sazuz and Hafaday, good morning, Mr. Chair, Senator Nicolas, and members of the Committee on General Government Operations. I am Joseph Cruz, and I am the Chief of Police for the Guam Police Department. As I start my testimony, I would like to thank this committee for allowing me with the opportunity to provide this testimony relative to Bill 303-34, an act to repeal subsection 10103 of Chapter 10, Title 4 GCA, and repeal subsection 5103 of Part A, Chapter 5, Title 2 of the GAR, relative to allowing investigative, intelligence, or security employees of the government of Guam to be represented by employee organizations under the Public Employee Management Relations Act. On May 2nd, 2017, the Guam Police Department submitted comments to the Director of the Department of Administration pertaining to GPD's employees' duties and responsibilities. The DOA Director affirmed that the Guam Federation of Teachers was filing a petition for exclusive collective bargaining rights of police officers 1, 2, and 3. GPD responded to the DOA request, providing information of duties and responsibilities of the police officer positions, which are consistent with exclusions delineated in Title 4 GCA and Title 2 GAR, therefore restricting the DOA Director's ability to certify the request of non-management employees in GPD as an appropriate employee unit, to which the Governor concurred. Although a majority of the force is made up of police officers 1, 2, and 3, of which there are 187, the Guam Police Department currently employs 296 sworn officers, 1 unclassified employee, and 59 classified civilian support personnel, totaling 356 hardworking and highly efficient individuals contributing to the public safety goals and objectives of our community. My responsibility is to address concerns involving the working conditions of the entire force. And since my appointment as the Chief of Police in 2015, I have put in the following systems in place. Number 1, I conduct biannual sessions with police officers 1, 2, 3, and sergeants 1, accompanied by my staff assistant, a police captain, and the police sergeant major. These sessions are exclusive to each rank and an opportunity to receive concerns regarding their working conditions. Number 2, I conduct mandatory weekly meetings with all management staff, which include police lieutenants and above, the police sergeant major, the administrative services officer, and the federal programs manager. Concerns are tabled for appropriate attention and response by management. And lastly, number 3, I have an open door policy for all GPD employees to address their concerns directly to me without interference. Cited in this bill is this body recognizing that an employee organization consistent with the Public Employee Management Relations Act is not poised to interfere with security requirements for reasons that government management officials retain the rights and responsibilities to A, maintain efficient government operations and direct public employees, B, hire, promote, transfer, and assign employees to government positions, C, suspend, demote, discharge, or take disciplinary action against employees for just cause, and D, to determine the methods, organization, and assignment of personnel for the conduct of operations, including necessary actions in emergency situations. Similarly, it should be noted that this body recognizes that an employee organization is poised in accordance with Title 4 GCA Chapter 10, subsection 101136, whereby public employees shall have the right to be represented by employee organizations when exclusive recognition has been granted to such organizations for purposes of consultations and negotiations with government management officials concerning terms and conditions of their employment not otherwise fixed by law, and the settlement of grievances and disputes. Additionally, in absence of exclusive recognition, management officials shall consult with otherwise qualified employee organizations when requested or on their own initiative regarding the formulation and implementation of personnel policies and practices on matters affecting government conditions which are of concern to the organization's memberships. On May 2016, GPD responded to information requested by the International Union of Police Associations, or the IUPA, which is the only AFL-CIO, also known as the American Federation of Labor, Congress of Industrial Organizations Union, chartered exclusively for law enforcement and law enforcement support personnel. Salary information for entry-level officers up to the rank of police captain was requested, as well as a, quote, collective bargaining agreement, end quote, or the lack thereof. As provided in their website, the IUPA works to improve legislation that protects and affects public safety officers, as well as representing the needs of law enforcement officers and support personnel, end quote. The IUPA and other organizations such as the Fraternal Order of Police and the Patrolmen's Benevolent Association have represented law enforcement officers for decades and for some for over 100 years. Police unions have had influence for law enforcement needs and the grievance in government echelons much higher than department level managers. Police union work is more apparent in the political arena, which has aided in the drafting of legislation impacting lives of not only their members, but also the law enforcement and labor community as a whole. The current national discourse is centered on the defense of officer-involved shootings across America and the outcomes of federal policy and legislation addressing those unfortunate incidents. If this bill succeeds, the Guam Police Department will support a union that will address concerns by the entire department, including management officials who retain certain responsibilities that this bill recognizes. All GPD employees, including civilian support personnel whose purpose directly contributes to the working conditions of the sworn officer, should be included in the formation of a bargaining unit. The role of police unions is no different from that of labor unions. Police unions exist to advocate for their membership, and legally, unions are responsible for representing their members. With the looming financial crisis brought on by Bill 26234, once again threatening mass furloughs across the public sector, we anticipate that a police union would insist from this legislative bodies a realistic source of funding to support a reasonable and stable budget for law enforcement officers from year to year. Therefore, on behalf of the Guam Police Department, we would support a bill that considers the recommendation mentioned herein and would request that this body consider the welfare of the hardworking men and women in law enforcement and the policing profession, as well as those personnel who support those officers. Thank you for your time this morning.
Thank you, Chief. We'll go ahead and start from the top down now, Mr. Officer Kress.
Good morning, Senators, gentlemen, and ladies present. My name is Richard Kress. I'm a veteran, and I've been with the Guam Police Department for over 26 years. In my 26 years, I have been the department's OIC for Juvenile Section, Internal Affairs, Record Section, Research Planning and Development, the Armory, and for a short period of time, the department's legal officer. Okay. I am here this morning to give testimony on Bill 303-34 that straightens union rights for our police officers because I believe we need a voice. When police officers first join the Guam Police Department and are trained in force multipliers, such as the PR-24, the expandable baton, self-defense technique, mace or pepper spray, in order to go out there and protect the citizens' life and property and the officers, in order to do their job properly, but that is the only time we get that training. We need a voice. When officers are forced to work 43 hours a week, that is an additional 4,680 hours, which equals to 2.25 years more than any other GovGuam agency within a 30-year career, without compensation for annual leave, sick leave, or retirement. We need a voice. When Title 10, Guam Code Annotated, Article 3, subsection 77301, states that there shall be 2 police officers capable of responding to calls for the first 2,000 people in a village, and 1 additional police officer for every additional 2,000 people in the village. On an island of 180,000 people, we have a total of 16 officers on duty capable of responding to calls. That's 1 for every 10,000. We need a voice. When the police officers are forced to work overtime against their will or face disciplinary action, we need a voice. When police officers are not being paid their overtime on time, we need a voice. When officers are being disciplined for not following general orders, when the department are not following those same general orders, we need a voice. When officers have received prejudicial, unfair, arbitrary, conspicuous treatment in his or her working conditions or working relationships, we need a voice. When police officers who are sworn to protect people and uphold the law are subject to go against their oath due to political influences, we need a voice. In closing, I would like to thank you for allowing me to testify, and I beseech you, please, do not let our voice fall silent, because in the darkness, a voice may be the only light we have. Thank you.
Thank you, Officer Kress. Officer Kirigua.
I support a union that's focused on police only, which would be the IUPA, and that's all I like to say. That's all I like to submit, is that a union that's focused on police work and police unions across the nation, and not any other union to represent us if this bill is, if it passes in the law.
Thank you. Mr. Koss.
Half a day, Honorable Senators, 34th Guam Legislature. I'd like to begin by thanking Senator San Nicolas for introducing his bill, and to further thank all the senators that are here today to hear the bill and consider the important matter. I'm here today to testify in favor of Bill number 303-34, introduced by Senator Michael San Nicolas, which purports to repeal Section 10103, Chapter 4, Title 10, and repeal 5103 of 2 GAR. The purpose of the repeal of these policies is to allow law enforcement the same opportunity to form a union and be represented by employee organizations in the same manner and fashion as all other public employees. Becoming a fully recognized collective bargaining unit is fully supported by a majority of the police officers on Guam who are already members of the Guam Federation of Teachers. And their request to be recognized as a unit is the next step in that process. But progress has recently been denied to law enforcement by the Governor of Guam. To justify the denial of collective bargaining, the Governor relied on the two policies that we're now asking you to repeal here today. It is understood that if this bill is passed into law, it will not directly grant recognition to peace officers, but it will provide the officers with equal footing in their effort to achieve this goal. The bill is really about equity and fairness in the treatment of all public employees. My name is Robert Koss. I'm a field service representative for the Guam Federation of Teachers Union. In my official capacity, I represent public employees and their personnel matters. In my position, I'm uniquely situated to hear and learn of the various concerns that peace officers have relative to their employment. Through my testimony here, I hope to help you understand why providing collective bargaining to police officers is important and convince you to support legislation that is good, not just for the officers, but for the people of Guam. Transparency. Beginning with an open and transparent government, whenever there's an appearance or cloak of secrecy around some government agency, a lack of communication, an authoritarian leadership, or a climate of fear, public trust is quickly lost. Employees become suspicious and unrest begins to unfold. Situations like this are not conducive to the efficient operations of the government. Granting employees recognition opens channels of communication between employees and management and provides transparency. Too many times over the last year, we've witnessed employees come before this legislature without representation and with a belief that somehow they would be protected. And then they reported to you alleged incidents of waste, fraud, and abuse. Many of the employees that came before you over the last year are no longer employed in the government of Guam. Most were terminated directly. Many filed whistleblower complaints, but none have been reinstated at this time. All suffered economic harm for engaging in activity this government purports to support and encourage. Granting employees recognition effectively creates a barrier or a buffer or a layer of protection for employees and members of the union from this sort of activity, and further serves as a check and balance for agencies where collective bargaining exists. Where there is collective bargaining unit in place, there's a constant monitoring of the daily operations through the eyes and ears of employees. If you want a well-functioning, cost-effective, and efficient government, unifying employees through collective bargaining is a highly effective tool for that purpose. There's economy in collective bargaining. There are also many economic benefits to granting collective bargaining for law enforcement. Collective bargaining is an effective and cost-saving tool for the government in the disposition of grievances and disciplinary matters. In matters involving employee discipline and grievance, there is no cost to the government, zero. for all matters where the union represents the employee. Each and every case where a union represents a member or group of members before the commission or other administrative tribunal is a freebie for the government of Guam. GFT does not bill the government for its services that it provides in ways that attorneys do. Indeed, this is a member-paid service, and there is no award for fees to a union. Absent union representation, employees typically hire attorneys for their administrative matters. Governments generally suffer substantial costs in the form of legal fees. In case you're not aware, when GFT is not involved, a single administrative proceeding can easily cost this government tens of thousands of dollars in fees. I might add, agency heads are often sitting ducks for skilled attorneys who represent employees in administrative proceedings. Where there is no collective bargaining, the agency is likely either bleeding out through costs or avoiding employee discipline altogether. Collective bargaining is ripe for law enforcement, and just because it's cost effective, moreover, because of fairness and equity. There's likely no group of employees that need recognition and union representation more than law enforcement officers. Peace officers carry a firearm, and they walk a fine line every day in the performance of their duties. There is protocol for everything they do and every situation they encounter. They put their life on the line, but just one time should they fail to follow protocol, the system will generate an immediate need for representation. Many officers lack financial resources for this purpose, and pursuing a career in law enforcement may be one of the most difficult occupations there is for this reason. Presently, police officers are denied representation during internal affairs investigations. In my opinion, this is a big mistake and opens the door for abuse. Mistakes made by the government are frequently made, and also by employees during these investigations. Government mistakes during its investigations may be costly and have very undesirable consequences. When there is collective bargaining, employees represented, many, most, or all of these mistakes are avoided. Peace officer granted recognition for representation is almost automatic. Few agency heads and public employees understand the subtle differences in the rights and responsibilities of the parties when involved in administrative investigations versus criminal investigations, or how the conduct of these investigations can affect both the government and the employees involved. Without union representation, our peace officers are at an unfair disadvantage, and they're placed at serious risk in every investigation they participate in. Without the union representing employees, the government is also placed at risk in making serious and costly errors. Again, mistakes are costly. Collective bargaining is an obvious path to a more cost-effective and efficient government. If peace officers' policies and procedures, if peace officers are permitted to engage in collective bargaining, the government will also reap tremendous benefits because for the first time, officers will have a meaningful voice in the formulating and implementation of policies and procedures that affect their working conditions that are not otherwise fixed by law. Employees will have a voice. More heads we involve in policy creation, the better the final product. Moreover, when employees participate, they're less likely to complain and grieve and generally more accepting of consequences. In the next few months, I anticipate public employees will be asked to make many sacrifices and suffer the brunt of the budget crisis. Having collective bargaining units in place and involving organized public employee units in that process would make that a much easier pill to swallow. Collective bargaining also improves employee satisfaction in the workplace. It increases longevity of employment. Recognized employee bargaining rights leads to better working conditions, better morale, and less turnover. It all adds up to a more efficient government and greater public trust. Officers stand ready and eager to obtain collective bargaining rights and have many really good ideas and some concerns that they're eager to share and address. For example, customs officers have a viable plan to reduce their operations by nearly $2 million a year and use that money to hire more officers to better protect our ports of entry and reduce the number of overtime hours that they must work so they can spend more time with their families. Others would like to participate on the Post Commission and have solutions that may make the PFQT actually workable. Some officers have children, and they need to find ways to ensure that their children are properly cared for while they're on duty 12 hours a day, 5 days a week. Just on that issue, daycare opens at 7, closes at 6. If you've got a 12-hour day, there's no way you can both get your children to daycare and pick them up. What are we supposed to do with our children? It's actually a very problematic one. Others are unhappy that the promotional opportunities are too few and far between. When opportunity does come, it's extremely contentious and plagued with allegations of favoritism and sabotage. Some officers feel that they're in dead-end jobs because they lack military background and cannot be promoted up the ranks under the existing law. These officers have researched best practice and they're eager to pursue them. But presently, there is no system in place where officers in the rank and file can participate or share their ideas. The system of silencing hundreds of employees only feeds frustration and dissatisfaction. Officers are given orders and expected to follow them. Most of us find it hard to accept authoritative leadership. In law enforcement, not only is it expected, but there's no mechanism in place to give due consideration to employee input and no mechanism in place to hear employees have to say. Systems appear to be designed to silence employees entirely, expect them to blindly follow every command. Employees that grieve are considered troublemakers, and employees that testify by this body are likely to suffer far more dire consequences should they deviate from their scripted talking points prepared by the authority. If this is how you envision things should be, then you should vote to deny officers collective bargaining. But if you want a better government, an efficient government, a cost-effective government that follows best practices and promotes positive employee management relationships and morale, you should not only support this legislation, but you should also begin to look at other changes to the system that, quite frankly, do not appear to be functioning in the best interest of the common working man. Peace officers stand before you today ready and willing to help, to offer information, suggest solutions, and provide answers, but remain without a vehicle to do so. Indeed, collective bargaining is the tool to get the job done. Through collective bargaining, we can virtually guarantee you a more physically fit, highly trained, highly skilled, highly qualified pool of law enforcement personnel serving the people of Guam. This may sound too good to be true, but there are ways to motivate employees, and who knows better than the employees themselves? I assure you together we can accomplish this. Officers would like to integrate innovative technology, new ideas and methods into law enforcement, such as the use of body cams and dash cams to improve protection of the people and the officers. Officers have so many ideas that will increase productivity and ultimately better serve our island, to keep them safe and the families that call this island our home. If only they were allowed to participate. Collective bargaining granted to peace officers will undoubtedly have a positive effect, but things worth having never seem to come easily, and this certainly seems to be the case here. Peace officers and all public employees need your support, beginning with this simple bit of legislation that repeals two policies that, quite frankly, are very unfair, unjust, and treat our peace officers in a disparate fashion in contrast to all other public employees. Peace officers want to take part in their future. Giving them the opportunity is indeed the right thing to do for them. I encourage you to support this bill, vote yes, repeal the language of the act that has prevented law enforcement on Guam from observing their constitutional right to form, join, and participate in collective bargaining. Thank you.
Thank you, Mr. Koss. Mr. Del Priore.
Good morning, Senator.
If you can,
at the outset,
Dan, if you can push the button on your microphone.
Thank you. That one. There we go. Thank you. Good morning, Senators. Let me say at the outset, if I appeal a little disorganized, I had to pick up a family member at the airport for something in the morning, and the flight was delayed. That being said, let me at the outset say the background by which I speak to you today comes from my working with the Guam Federation of Teachers as a field representative, but also as having been a chief negotiator for a number of collective bargaining agreements with government agencies such as Guam Waterworks Authority, Department of Public Works, Guam Memorial Hospital Authority, Guam Fire Department, Dodea Bus Drivers, which is private. So I have been involved with negotiations on contracts, collective bargaining agreements. And I can say at the outset, these agreements, of course, address the individual agencies and the employees and their needs. Also, before I omit that, let me say I am most pleased that the management of the Guam Police Department acknowledges the desirability of a union labor organization to represent the rank and file, their employees, to participate in the operation. That being said, we are not here today to discuss whether the petition or the request of Guam Federation of Teachers to be the labor organization should be granted or not. We are here today to address a proposed bill that would remove the exclusion that this governor has placed on the ability of any labor organization to represent what is called law enforcement, those certain categories of GovGuam classified employees that are in such agencies as the Guam Police Department, Customs and Quarantine, Department of Corrections, the Rangers with Agriculture. Why are we here today when PEMRA and 2GARR has been in existence for years? Well, I also authored the petition for the police and the Customs and Quarantine to be recognized as a unit, officers 1, 2, and 3. The chief mentioned that a labor organization for all of the department would be desirable. That is not what we're concerned about. Department of Administration defines what a unit is. So we particularly put forward officers 1, 2, and 3 as a unit. That petition was set up, and Chief Cruz did respond and say he has an open door policy and like that. Management has power and responsibilities, and that's desirable. But not always will the rank and file feel that they can come individually. As the officer mentioned, a voice is desired. Plus, however meritorious Chief Cruz might be, he will not be the chief of police forever. So an organization that continues on can provide the continuity for good performance. Guam Federation of Teachers has been in existence on Guam for more than 50 years, and the governor just renewed it again last year for another 50 years. So GFT is a stable union labor organization that can provide continuity. But we're not here to say yes or no to the GFT petition. Should we remove this exclusion which Governor Calvo has placed? And again, why are we here today after so many decades of PEMRA? Because in my preparation of the petitions for the police and Customs and Quarantine, I worked with Sandra Miller, Chief Legal Officer for Governor Calvo, and never has any prior governor ever invoked the exclusion aspects of PEMRA and 2GARR. In his denial of the appeal of the petitions, the governor said he is most concerned because if a labor organization were involved with law enforcement investigative, they would be entitled to negotiate specific terms and conditions of employment. Well, that's part of what can be negotiated, but it's not all of it. And if you read PEMRA, negotiations are bilateral. What does bilateral mean? Between two parties, the labor organization and management. What does negotiate? Discussion, talking, compromise with management and the labor organization's representative. Who are the labor organizations? The men and women of the department are the stewards and the chairs of the unions that can sit down with management, not in antagonistic, but in a manner, how can we improve the organization? For example, when GFT, which is recognized as the labor organization for the Guam Fire Department, began our collective bargaining negotiations, the fire chiefs and Nicolas said, can we do a survey? You do the survey because then it's coming from the labor organization. What do the men and women of the Guam Fire Department want? What are they concerned about? So that then when we sit down with management, the two negotiating teams can try to make a good collective bargaining agreement that addresses the needs and concerns of the department. So it's from this aspect that we say negotiations of working conditions are appropriate because they're not the same across GovGuam. DPW bus drivers work steadily during the 9 months of the school years. What are their working responsibilities and conditions going to be during the summer months? And we can work together, any labor organization and management, to make that effective. The same thing with the fire department. What kind of, they work to get the credit for the 120 hours when they're on the duty. What kind of credit is given to them when they take their leave. Management can work together with a labor organization. And the bottom line is, any negotiations, it says in PEMRA, are subject to paramount law. There can be no strikes on Guam of GovGuam classified employees, so the law still controls. The Chief Cruz talked about management's responsibilities and authority to run the organization. Yes, that's spelled out in PEMRA, that management has the responsibility for the day-to-day organization. It's the same as involved in the collective bargaining agreement between the Guam Federation of Teachers and the Department of Education. We ask that the Department of Education, when they're talking about transfers, consider seniority and the needs. But the ultimate power is recognized in the collective bargaining agreement for the superintendent to carry out the needs and responsibilities of operating the Department of Education efficiently. It's recognized. Somebody has to be overall responsible. But that the police and the law enforcement members, men and women of these departments and agencies, should have a voice and an input, yes. You don't need a doctorate in psychology to know that if you have a stake in what is going on, are stakeholders, then you are more supportive, you are more involved. And this is true of the men and women that make up the law enforcement agencies. And again, never before has there been anyone saying you cannot have an organization. I submitted, and the chief mentioned, there are national organizations of law enforcement throughout the country. And I looked up a number of them. In Houston, the Houston Police Department has had their union since 1945. And they're throughout. I'll provide samples of Dade County, Miami, San Francisco, Las Vegas, all the police departments have their own union labor organizations, which come together in umbrellas. And not just the police department, the National Treasury Employees Union covers the Customs and Border Protection of the federal government. So Customs and Quarantine, likewise, in the U.S. government, is allowed to organize and participate, and has been essentially an organization since the 1930s. There is no danger or threat if the bill is passed that allows the law enforcement agencies of GovGuam to form labor organizations, to engage in collective bargaining agreement, to bring the needs and concerns of the men and women and how to make the department more effective in serving the people of Guam. These men and women who serve in the classified service, we can't negotiate salary, so we can discuss better working conditions and situations. The labor organization can support the equipment, the needs of the organization, and allow the men and women, not just the chiefs, but the men and women of these department and agencies to work together with the national organizations to see what has been done there and how we can improve what we do here in Guam. It is not a need, there's no need to be afraid of the men and women in the classified service of our law enforcement agencies. There are parents, our brothers and sisters, our aunts, our uncles, and they have a need and desire to serve too. What we just need to do is give them the opportunity to work with their management to make the system more effective for the people of Guam. Thank you.
Thank you, Mr. Del Priore. You're pretty good for somebody who didn't get a lot of sleep this morning, so. That concludes the individuals who signed up to testify. I wanted to make a couple observations. First, that Chief, I thank you for your testimony. I didn't hear necessarily that there was opposition to the formation of a union within the Guam Police Department. You're open to the idea, is that correct? If you can just put it on the record, please.
Yes, I am.
Okay, thank you, Chief. And I appreciated the clarification from Mr. Del Priore. The bill is very specific. We're not mandating any specific union to represent any law enforcement agency. We're simply removing the restriction that's prohibiting any organization from representing anybody in the law enforcement agencies. And so once we remove that, then it'll be between the officers and whatever labor unions they want to go with. We're not going to get involved in that, but we are going to open the door for you guys to figure out how you want to be represented. And I very much appreciated the testimony from Mr. Kress, where you're absolutely right, a voice is critical. And the reason why that voice is critical is because we have to make sure that whatever is being implemented throughout these agencies is going to be done in a manner that's going to be most able to be executed by the people who are being asked to do it. I'm married to someone in management. She's a principal. And I must say that at the very least, with respect to Guam Federation of Teachers, Mr. Del Priore, you're absolutely correct. There is nothing to be afraid of. Whenever you're talking about bilateral negotiations based on mutually agreed terms and conditions, in the end, it's all adjudicated, and what is right is what happens. And so I'm very excited about the opportunity to be able to move this bill forward and to allow for our law enforcement to finally be able to be represented, so that you guys can come together and make sure that a lot of these long-standing issues that many of you come to us with indirectly, you guys send us emails, you give us calls, and oftentimes it's not a political solution. It's a management and labor issue that you guys need to be able to work out. But when you're able to actually collectively bargain, then it's no longer one individual complaining, but it's a group coming together with ideas and solutions. And I think that it'll be a very, very good thing for our law enforcement agencies. And I think that it'll solve a lot of the long-standing problems that many of us have heard over the years. So I thank you all very much for your testimony.
Mr. Chair, if I could just comment for the record.
Sure.
Just to be clear, in the last comment you asked me, what I would support as the Chief of Police is a police labor union. A union that supports police officers, that understands police officers and what we do here on the island of Guam. That's what I'd be willing to support.
Sure. This bill does not prohibit the formation of that. If
Yes.
you guys want to create a police-only union, that's
Yes.
entirely on you. But this bill would remove the barrier from that being
Yes.
able to...
Not taking anything away from any of the other bargaining units.
Sure.
But like Major Kidego had said, and based on the research that we've done in management, just like jurisdictions, police jurisdictions stateside, those labor unions are specific to police officers in that particular jurisdiction. And that's what we would be willing to support.
Understood, Chief. Thank you. Do any of my colleagues have any questions? I'll yield to the Oversight Chair, Senator Nelson.
Thank you, Mr. Chair. Mr. Cause, if this bill should pass, would our public safety officers be able to avail to the GFT union?
Yes, ma'am. Yes, ma'am. Actually, the majority of the police officers are already members of the Guam Federation of Teachers, and by being members, they already receive representation and certain benefits. The bill would largely make it more possible for them to engage in negotiating a collective bargaining agreement, and that's the primary benefit that is still lacking. There are aspects of working in law enforcement that really aren't well addressed by law, and those are the needs that we need to focus on.
Because you already have clients under the GFT union, or that are police officers, do you feel that GFT is can be a just representative for these officers, or is there something that a police union can do differently that GFT does not offer?
Senator, the grass is always greener on the other side of the fence. I would caution anyone who thought that maybe an off-island union might be more effective than a local union, because you're not going to have the facility and the physical representation and support that you get locally. I do not believe that off-island unions provide better service, and I also don't believe management. And there's another section of law that prohibits management from organizing. And so, the Chief's contention that we should include all officers would require another amendment to the law.
Thank you very much, Mr. Koss. Chief, just a quick question. You continually state that you would prefer a police union, but it doesn't necessarily give a direct answer whether you support this bill or not. And so I'm just inquiring, have you discussed this with the members of law enforcement about a possibility of a union, a police union to your preference. Has there been any research in that case? Is there any movement on that?
We are still having discussions to that matter, Senator. We haven't made any hard and fast decisions. There are off-island police unions that have reached out to the Guam Police Department, as I had indicated in my testimony, but we have not, because of the way the law is crafted, we have not had any discussions with them. We are, as management, we are willing to look into this further and look at what would serve the Guam Police Department best. But again, I understand Mr. Cost's concern that the bill is specifically to law enforcement officers, and I understand that. But at the same time, I have a responsibility to look out for my civilian employees who oftentimes feel neglected because of the fact that they don't wear a uniform and they don't do policing services per se. So what I am looking at and what I am supporting is a bill that supports that supports the overall welfare of the entire police department. And if it means looking at another bill, well then so be it. I'm looking out for the entire police department, of which I have civilian employees. So to answer your question directly, we have not had any negotiations. We have done some research online to see what is available with the Fraternal Order of Policing and then the Police Officers Benevolent Association. And those are things that we can continue to look at to make a better determination on what would be the best bargaining unit for the Guam Police Department. And again, our interest is to look out for that which we do in law enforcement.
Okay. Thank you, Chief. Thank you, Mr. Chair.
Can I submit a comment on that? Some of the issues that are differentiate between police unions and other unions in the United States, and this is just cursory research that I've done over the last couple of weeks when we discovered that the bill was up, is that dues that are paid for by those in organizations that are in law enforcement were, until recently, a required payment, whether you were a member in good standing or you chose not to be a member of the union. They were required. But a recent Supreme Court ruling, the U.S. Supreme Court ruling, Janus v. ACFME, does not require, no longer, if you're a member, if you choose to opt out of the union, you no longer have to pay required dues. So that may have an impact on unions across the nation because it's a Supreme Court ruling, and we may and the FPO, the Fraternal Order of Police, the FOP, is saying that it's, the president there is saying that it's probably going to be like a death spiral because people are going to opt out. They're not going to choose to pay the dues and support the work that's done for all of those in police organizations and the labor community as a whole. Their work is beneficial for those rank and file, and it's going to be very hard to do that without the funding. So we may see some changes with respect to union dues and what funds their work in the near future, in the very near future. So I think that's what the difference was. It's what blares out as a distinction between unions in the police department or other unions, teacher unions that exist in the United States or other types of unions. I know we have a electricians union here and several other unions that exist on the island of Guam, but we kind of focused on research with police unions in the nation.
If I may just add a point, he's talking about the U.S. Supreme Court decision that was dealing with fair share, which has never been applied out here with GFT. If you had a Ford factory with 10,000 employees, 7,000 union members, but they represent all 10, the other 3,000 would pay a proportionate share of the cost of representation. But the accounting and the cost of accounting is significant to try and compute that. So it's never even been thought about or implemented here in Guam.
I appreciate all the union perspective. The reality is the bill is not going to really pick or choose one union either way. I really think that the labor, they're the ones who are going to decide how they want to be represented. I think that just focusing on the need for us to be able to access that representation, whether it's a police officers union, whether it's GFT, right now you can't access anything. And so the whole point of the bill is to at least create the access. Vice Speaker, did you have any questions, sir?
Just in follow-up to the previous questions, very similar, just wanted to clarify one more time. In one of your letters, it says that you've petitioned for exclusive recognition on behalf of Guam's law enforcement peace officers. Does that mean GPD and the port, or GPD and customs, or which ones? Or all of them, just as a group? How did you describe your...
Sorry. I'm sorry, ma'am.
One of the letters I'm reading says, GFT has petitioned for exclusive recognition on behalf of Guam's law enforcement peace officers. Is that all the peace officers that are covered by this bill?
As was mentioned by Mr. Koss, there are restrictions on management being involved in a union. I have seen, like in the Houston Police Department union, it goes up to the rank of lieutenant only. In other departments, like in Miami or San Francisco, to the rank of sergeant. In our petition, we sought officers 1, 2, and 3 because the unit, as defined in PEMRA and 2GARR, should have common purpose and common focus. So we thought at the outset, because this is the first law enforcement petition, to make a simple unit that DOA would have no problem in accepting.
Did that include just GPD and customs then?
Customs was officers 1, 2, and 3 also.
Presently, Guam Federation of Teachers has majority membership for the Department of Corrections, Customs and Quarantine, and GPD. Of course, none have been recognized.
Okay, so customs, DOC, and GPD.
DOC,
GPD.
CQA, GPD.
Oh, customs. Right. Okay, so the 3. This bill also covers the port. Are they already covered, or were they already allowed? Well, it says port security inspectors, not all port officers, but what's the effect of this on?
Ma'am?
This GFT?
My hearing,
Sorry.
I'm seeing my hearing doctor. If you could speak up a little bit, please.
All right.
I can field the question if you like.
Please.
Go ahead.
Yeah, there are a limit on the size of bargaining units. I believe 20 or fewer employees is insufficient for a bargaining unit. I'm not sure how many officers are at the port. The change of this statute would make them eligible for collective bargaining if there are a sufficient number to create a unit. Small units are very difficult to manage from the union's perspective. Yeah, Park Police, I believe we would include. We would look at Department of Agriculture as conservation officers, anyone who's recognized as a peace officer.
All right. And then immediately upon passage of this bill, what would change regarding collective bargaining? Does that kind of authorize you to proceed with collective bargaining if you have, it says here, the majority of officers have expressed their desire, support, and need for collective bargaining?
Right. So granting of recognition remains at the discretion of the governor of Guam. Nothing will change. The governor will still have that discretion. I think this would cause him to rethink his reasons for denying the officers collective bargaining, perhaps give them another opportunity to seek recognition rather than waiting for a new governor.
Is there a number that's required to represent police officers, for example?
There's two ways recognition can be granted. One is, I believe, you obtain, what is the percentage?
50%.
Well, no, that's the membership. There's we could do a card passing where employees don't necessarily join the union, but they sign that they would like to be represented by a union. When we have a majority of employees who support having a union, we can call for an election, and DOA would then conduct an election, and based on the outcome of the election, the employee's recognition could be granted in that way. There's another way that we prefer, which is more or less should be automatic, and that is when a majority of employees become dues-paying members of the union, recognition should follow. And that's basically, the process that we have tried to implement with peace officers, but so far that has not been successful.
So if that's what your petition's based on, majority of 187 officers?
Correct, 51%.
All right, okay, thank you very much.
Mr. Majority Leader.
Has there been any research as to what was the underlying thinking when these exclusions were mandated back, I guess, during the 9th, back in '68? Has there been any research as to what was the thinking then?
From the perspective of management, Senator, no, we have not done any background investigation. We have not dug that deep. We have not delved that deep into the matter, trying to understand what Governor Guerrero's intentions at the time were in signing this, that law. We can definitely try and look into that to understand the spirit and intent of the law as we understand it, but we have not done that kind of background investigation.
Okay. I think as a follow-on to Senator Nelson's question about the climate in GPD or receptiveness towards a union, I gather there's been no survey or anything as to the receptiveness of the officers to being represented by a union?
Like I said in my testimony, Senator, I have biannual meetings with Sergeants 1 and below. And during those meetings, there have been no discussions, and my staff assistant takes notes for me in that matter. We address these particular issues that would normally be handled by a union with regards to working conditions. Management deals with that, and we address those concerns. Has it been brought to my attention specifically? I will tell you that it has not been specifically brought to my attention about this matter, and I think it's because of the fact that everybody reads the law and sees that they're excluded from representation through that particular act. So to answer the question directly, Senator, there has not been any discussions between the lower rank and file and management with regards to looking into unions. But again, if it's brought to my attention, that's something we can discuss. And we have talked about it when the IUPA sent us a letter. We did talk about it when the GFT sent us a letter, and it always reverted back to what the law allows. And if the law doesn't allow it, then we never pursued it further.
Okay. All right.
Sir, I can answer. I am one of those PO1s, working class, and I've talked to my coworkers, and not one has expressed their desire not to have a representative.
Not one has expressed the desire not to have.
Yes.
Okay. Tell me if I'm wrong, but it seems that the climate is fertile for the entry of a union when management is really doing a poor job. Would you agree that that's the case?
Well, it's a interesting reality that controversy is good for unions. But that's really not what unionizing is about. It's really about promoting positive public employee management relationships. I would point out to you here today, you have two peace officer divisions present, GPD and Customs and Quarantine. Both of these agencies have agency heads in place who have an open door to the GFT, who are available to receive our calls and discuss matters. There are other law enforcement agencies here who are not present, or I'm sorry, there are law enforcement agencies who are not present here. And there's a very different position with those directors with respect to the union and representation of their employees.
Back to the initial question that I asked as to what may have been the underlying thinking when these exclusions were mandated. And now I guess I'm going to have to go do my own research, because it just seems that in a paramilitary organization such as the Guam Police Department, admittedly I do have some concerns about, so by having the union in there, does that dilute then the authority of, your upper management?
I understand, Senator, and those are things that we're going to take a look at as well. Yeah. We always, from the law enforcement perspective, we look back to what similar jurisdictions across the nation are considering. Not to say one way or the other what are hard and fast, which particular bargaining unit would be there, but again, we just look across the nation and we see what some of the trends are, what's happening there. We look at the legislation that they have to deal with as well, because that has a play into that bargaining unit and their ability to bargain. I do understand your concern, Senator, and that's something, again, that we will take a look at to understand what the legislative intent was when that law was signed back in 1968.
Yeah. And one last thing is, I listened to your testimony, and things like, I know a lot of the officers would like to have the body cam, and I guess other equipment that they feel, they really need. And I'm just not convinced that a union is going to provide you with that, as opposed to maybe that's a reality of the fiscal constraints that the department, has to deal with, in addition to the other legal aspects to that. So I guess Mr. Mr. Cos did say that the other side always looks greener, but so
right. There's actually federal grants available for obtaining the cost of those products. When it comes to the use of the products, I think it's the agreement between the employees and management on the rules on how those products are going to be used in law enforcement. And that's, I think, really what we're talking about when we talk about collective bargaining, is management and the employees coming together and agreeing that, this is going to be our policy. Anytime you introduce technology, there can be many concerns, privacy concerns, for example, when cameras are involved.
So let me just close my remarks here by saying that generally, I'm receptive to a union being a part of the organization. I don't share that same receptiveness within a paramilitary organization such as the Guam Police Department. So I'll just leave it at that. Thank you.
Unfortunate, sir. I hope you'll consider the benefit of the government and the public employees in your decision. Thank you.
Vice Speaker, let me go around for everybody first, and then we'll Senator Castro, Senator Rodriguez. Senator Espadon, do you have any questions for us? Okay. Vice Speaker.
In the denial, was there any explanation based on policy besides the law? For example, what the Senator was just talking about, whether there's a policy that...
Quite frankly, when I read the letter, it appeared to be a misinterpretation and misapplication of the existing policy. I think Mr. Del Pior pointed out that the policy itself does not forbid collective bargaining for peace officers, but it has been, in my opinion, misinterpreted by the governor with respect to the request for recognition. Concluded the letter with, I don't really care about your constitutional rights, take it to the court. So, I think that perhaps the governor may have concerns that he didn't actually express. I don't know.
May I say at the outset, though, one particular point that I omitted before is, as I said at the beginning, the governor said that because collective bargaining could address working conditions, requirements, and terms, and this is law enforcement, we shouldn't have that. But the governor omitted the fact that, that the bottom line is, he controls the collective bargaining agreement for the line agencies. It says specifically in the law, no collective bargaining agreement becomes effective until approved by the governor. So you have the bilateral, both sides have to agree. It's negotiations, you talk and look at it, and because they're line agencies, they don't have their autonomous boards or corporations, it goes up to the AG for review and to the governor for approval. So if he didn't like anything that's in there, he can say no. And because they're line agencies under the executive branch, that's the way it is.
Thank you. Are we able to see a copy of your petition and the response or the rejection?
Yes.
Oh, thank you very much. Thank you.
We'll go ahead and receive that and include it in the committee report so that all members of the body can review it when the bill becomes an issue on the floor. Any other questions from any of my colleagues? If none, gentlemen, thank you very much for joining us today. Thank you to all the officers for being here. I know that you're all very busy. Thank you for making the time. CQA, thank you very much. Now go ahead and conclude the hearing on Bill 303-34. Next on the agenda, we have Bill 272-34, and I'll yield to Senator Tina Lynn Nelson for her opening statement.
Thank you, Mr. Chair. 272-34 is an act adding new subsection to subsection 6303, Article 3, Chapter 6, Title 4, Guam Code Annotated, relative to requiring reporting of amended government positions and deferring the filing of amended positions. The merit system is used for...
1 minute, Senator. I'm sorry. Could we have some order, please, in the hall? If we could have some order, please, in the hall, and have everybody please depart the hall.
The merit system is used for classified government positions in order to ensure that they are hired based on their ability to perform the job. The merit system is used for classified government positions in order to ensure that they are hired based on their ability to perform the job, rather than their political connections. Unfortunately, this system may be circumvented by amending position requirements to cater towards the qualifications of certain individuals. While others may also try to obtain said qualifications, they may not be able to do so in the limited amount of time from when the amended position is posted to the time the position is closed or filled. No candidate who was initially qualified prior to an amendment should be impacted by such an amendment if they were not given ample time to comply with the amendment. Just a little bit of history for the initiation of this bill was the situation with one of our public safety agencies promoting individuals, and at some point in time they would amend the qualifications for a certain position. Qualifications that would either was specifically tailored for a certain position. And so the challenge is some of the requirements for certain qualifications that are amended in the mid-process of hiring or application placement. It was impacted because some of these certifications would take perhaps 6 months or to a year to acquire. So in the midst of this, it discredited some of those that were eligible. And so really the meat of this bill is the last item in Section 4. If a position's qualification were amended and the position must be filled prior to the 180-day period, the last approved position qualification shall be used for selection. No penalty shall be applied to any applicant who does not meet requirements for an amended position description that did not complete the 180-day period. Thank you, Mr. Chair.
Thank you, Senator Nelson. For 272, we have Mr. Ed Byrne, who signed up to testify.
Senators and Nicolas, Senators, thank you for the opportunity to provide comments on Bill 272-34, which is an act to add a new subsection E to Section 6303 of Article 3, Chapter 6, Title 4, Guam Code Annotated, relative to requiring reporting of amended government positions and deferring the filling of amended positions. Department of Administration supports Bill 272-34 with amendments. Although the DOA has several comments focusing on sections 3 and 4, we offer some recommendations that we believe will improve it and fulfill the intent of the bill, which is to provide time for potential applicants to meet amended qualification requirements and to provide transparency as is currently mandated by law when positions are created. DOA sees the timeliness of a position being filled after an amendment is effective a concern for departments should the bill become law as written. Section 3 states, no amended position may be filled until after compliance with the provisions of this section and 180 days have elapsed from the date of filing with the Legislative Secretary. The 180 days period is a considerable time to wait before a department can fill a position after an amended qualification requirement. The concern is the 180-day period would add to the time it takes to complete the recruitment process. The bulk of the recruitment process which occurs prior to filling a position may take 60 days or possibly longer for certain positions where hundreds of people may submit job applications. The recruitment process includes announcing for the position, accepting job applications, evaluating the applications, employment testing if applicable, and establishing an eligibility list. Thereafter, additional time beyond the initial 60 days is taken to accept rating appeals and then generating a certification list which is needed to conduct job interviews. The department then schedules and conducts interviews, and the interview panel makes recommendations to the appointing authority. Where the filling of the position takes place is towards the end of the recruitment process, when the appointing authority of the department indicates on the certification list whom he or she has selected to fill the vacancy based on job selection interviews. From there, a recruitment GG1 is routed with the selectee's name, which leads to drug testing and the eventual filling out of the required processing documents to begin the first day of work. The additional time beyond the initial 60 days is difficult to project because it is dependent on several factors, such as the number of rating appeals to be addressed and the hiring department itself. Instead of taking 6 months for a department to fill its position, it could take 8 months or more when a position's qualification requirements are amended. Thus, Section 3 could have the unintended consequence of causing significant delay in the filling of positions each time a position's qualification requirements are amended. Departments typically want to fill their positions as soon as possible due to the need to meet their missions and objectives. In some cases, departments may have staff shortages in critical areas. They may need to fill multiple vacancies for the same position and may face a potential loss of or reduced funding if this is not spent on their vacancies by the deadline. We realize, though Section 4 attempts to address the timeliness issues mentioned above with regards to the 180-day waiting requirement before an amended position may be filled by utilizing the last approved position qualification for selection if the position must be filled prior to the 180-day period. However, the implementation of Section 4 may also result in several issues. Section 4 could be interpreted to imply that our department should just re-rate applicants based on the last approved position qualification requirements. This would not be fair, though, because the job announcement that applicants had applied under would have been based on the amended position requirements. Applicants who took the time to qualify under the amended qualification requirement may complain. They may feel they are penalized for following directions by doing what was necessary to meet the amended requirements. To be fair to all applicants, we would have to cancel the announcement and then re-announce the position utilizing the last approved position requirements. This may be considered to cause confusion and frustration among the applicants and would add more time to the recruitment process. To attempt to avoid any perceived unfairness and comply with Section 4, our department would have to ask the department before announcing for the position if they anticipate the need to fill their vacancy prior to 180 days, and if they did, announce with the last approved qualification requirements. More than likely, as stated above in the comments under Section C, a department would want to fill their vacancy prior to 180 days, since most, if not all departments, would want to do that. We foresee that Section 4 is that amendment to the position qualifications requirements would most likely not become effective, no matter how important they are, because Section 4 would require the use of the last approved requirements. Departments request to amend the qualifications of a position for various reasons, such as to obtain higher quality of applicants, to obtain a larger pool of applicants, and to adapt to an ever-changing environment that the position operates in. Thus, Section 4 may have the unintended consequence of preventing positions from evolving each time a position is amended. With the above, DOA suggests the following to the bill. Delete Section 4 in its entirety, modify Section 3 by changing the word fill to announced, and modify Section 3 by shortening the waiting period from 180 days to 90 days. We believe our recommendations will strike a balance between the needs of the department to fill the position and the desire to fill the intent of the bill, which is to give time to applicants to meet new requirements and to provide for the same level of transparency as is currently mandated when positions are created. DOA would like to thank you for the opportunity to provide comments on Bill 272-34, and I'd be happy to answer any questions.
First, yield to the author if she has any questions for Mr. Byrne.
Okay. Thank you, Mr. Chair. Mr. Byrne, is that input from your HR personnel, from what you wrote? Is that input from Shane Nagata? Your testimony, was he conferred on that matter?
Yes, I believe you asked them to input some comments, and these are they.
So those are you're reading off of HR's comments?
Yes.
Okay. And just to share with you, the meat of it is really the one that you want us to delete, is Section 4, is because midway when we were doing the research and the promotions, excuse me, in our public safety agency, we noticed that in some instances, that midway of accepting the application, the job description and qualification requirements changed. And so it almost automatically seemed that because the directors had the authority to amend these positions, and then DOA just complies with it because that's the director's authority of the agency, it's almost blatantly obvious that they amended the position to support or specifically tailor it to certain individuals, and that's why we pushed this bill forward, is specifically to challenge that, because it created an unlevel playing field for the others, and also speaking with your previous successor, Christine Belletto, that was some of the concerns we raised. So thank you. But thank you and we will definitely look into your recommendations. Yeah. Thank you, Mr. President.
Thank you, Senator. I understand your points. Right.
Okay, thank you.
Do any of my colleagues have any other questions for Mr. Byrne? Vice Speaker.
Thank you, Mr. Byrne. Mr. Byrne, do you think this bill then addresses the concern that my colleague, Senator Nelson, raised, is that what happened in the past was the announcement had already been made for upper-level positions that had not been filled in many, many, many years. So finally, they make the announcement, and in the middle of that application period, it's my understanding, that's when the qualifications change, which in effect did not allow many members or many people to qualify themselves for that position because of the short notice, because then it was ongoing recruitment at that point. And so for me, the notice has to be, well, for me, to address that, if I want to be promoted, then I should know what the goal is, and I should know that as far in advance as possible, and it shouldn't be changed 30 days into the process so that there's no way I can go and take the course or whatever else is needed to qualify for that position.
Yes, Senator, I understand the intent, and indeed some of the position descriptions and requirements that I've noted date back a long way, and that possibly is the reason why they're amended. It obviously would be better to amend them before you advertise for the position, but some of these, as you know, go on for a long time, and by which I mean, trying to fill these positions takes a long time, and getting people sometimes to apply for these positions takes a long time. So, but I understand what you're saying.
Do you have any recommendations how to address that then? I mean, would it be, well, I don't know. What do you think? Besides updating all position descriptions, I guess on an ongoing basis, managers could be doing that, right?
Yes, and I will go back and talk to the HR department about that, because I think that would be a step in the right direction.
Do you think we should prohibit changing a position description after an announcement has been made?
Well, the problem with that is that conditions can change. Sometimes if it's a qualification, the outside body that frames that qualification sometimes changes it spontaneously, and then you wouldn't catch up with that. And I don't think that would be that you wouldn't want to do that. So external circumstances might change the qualification, and we wouldn't want not to recognize that.
All right, thank you very much.
Any of my colleagues have any questions for Mr. Byrne? If none, Ed, thank you very much once again. This will conclude the hearing on Bill 272-34 and take us to our next agenda item, which is Bill 219-34, and I'll yield to the Prime Sponsor, Vice Speaker Therese Terlaje.
Thank you, Mr. Chair. Bill 19-34 was one of 3 bills introduced, which were intended to help promote the Registry of Veterans under the Veterans Affairs Office, so that the Veterans Affairs Office could fulfill its mandate in providing services, announcing services, contacting them for, when there are new government services or benefits that they might be eligible for, and just generally assisting our veterans. And so this one particular bill was going to utilize current processes conducted in the mayor's offices and kind of piggyback on that to allow additional information to be taken by the mayors when they are conducting an annual census. So mayors are currently under 40112 of the Title V mandated to conduct an annual census and maintain a current listing of names of all residents in the jurisdiction. So this bill would add on that a mayor could inquire as to whether the person they are speaking with is a veteran, and if they could submit their information to the Veterans Office. The other thing is that this bill would do would be to add another duty to the list of duties of the mayors, and this is simply to when they are processing. They are going to process, in order to get the new driver's license, mayor's roles they're going to have to process or certify whether these people are members of their village. And so in doing so, we would ask the mayors to inquire again whether they would, whether they're veterans, and whether we can include that in the information that's being sent to the Department of Revenue and Taxation. It would require a change in just village certification, and also that this person is a veteran. The other thing that it added was to conduct semi-annual community outreach within the jurisdiction for purpose of updating the Guam Veterans Registry and connecting veterans and their families to services. I'm hoping that this doesn't really add an additional burden to mayors, because I think mayors, almost all of them, conduct activities at least annually just for their villages, for example, fairs or festivals and things like this, or whatever other programs that they are doing. I'm hoping they can just add, solicitation of veteran status to their existing programs, so that it would help to just another avenue to help the Veterans Affairs Office seek these people and add them to their registry. Thank you, Mr. Chair.
Thank you, Madam Vice Speaker. For Bill 219-34, we have signed up Mr. Joe San Agustin. Sir.
Vice Speaker, Mr. Chair, Honorable Senators, good morning. My name is Joe San Agustin. I am the Special Assistant to the Governor, Administrator, Guam Veterans Affairs Office. I am here to testify in support of Bill 219, an act to amend subsection 40112 Mike of Chapter 40, Title 5, Guam Code Annotated, and add a new subsection 40112 Tango and subsection 40112 Uniform, Chapter 40, Title 5, Guam Code Annotated, relative to authorizing mayors to offer veteran status data on verification of residency forms, to include solicitation of veterans' demographics in their annual census, and to conduct a semi-annual community outreach effort to verify the veterans' population in their jurisdiction for the purpose of updating the Guam Veteran Registry and connecting the Guam veterans population to available services being provided by the Guam VA State Office and also the Federal VA. I am really 100% in support of this bill. I was hoping that I would be able to see a few mayors and vice mayors this morning. I apologize. I think I should have taken the initiative to make contact to several of them just to get a feel of what they think of this bill. In saying that, I did highlight my concern with regards to Section 2 and 3 of the bill. My duties, jobs, and responsibility is to support our mayors and vice mayors in pursuing these efforts as we move forward and try to do good and better things for our veterans and their families. I take it for myself, and I should, I think, be smart enough to add this to a standard operational procedures that in this initiative, as we do ask the mayors to assist us, that we also as an agency be very proactive with the respective village mayors to involve ourselves during their outreaches and just not to rely on them to do the data collection on their own. I say this for several reasons. We have the information of what needs to be provided for the veterans as to why it's important for them to register. We have the information with regards to benefits And many of the questions that many of our mayors are not able to answer the veterans when they do the outreaches, I really think that our agencies should avail themselves to be present during all these events. So I'm saying that I actually did language it, that with regards to Section 2 and 3 of this bill, powers, duties, and responsibilities, as it might appear to be an additional burden to our hardworking village mayors and vice mayors, the Guam Veterans Affairs State Office will work diligently to ensure that the process is seamless and painless as possible. I would also like to thank the author of this bill, the good old Vice Speaker and Senator Dennis Rodriguez, and all the senators that are here this morning, that please support this bill. It is as simple as I language my testimony. But lastly, also, I would like to thank the veterans and the active duty service members that continue to serve our country and our community, and you all senators as well. Thank you. I'm open for questions.
Thank you, Mr. San Agustin. Madam Vice Speaker.
Thank you, Mr. San Agustin. I also want to acknowledge your efforts to actually do outreach in the villages, your continued efforts. So thank you for that. And I, too, had discussed this at the Mayor's Council. I asked to be put on the agenda so that I could discuss this proposal with them to ensure just that it would not be an extra burden. And their concerns really were what types of forms are, going to be allowed or not allowed. And so I'm open to amendment of the bill as we did on the floor of the other bills, where we kind of expanded the types of forms to be consistent with what your office uses and what the Department of Revenue and Taxation is recognizing. And I also want to point out that this is optional. So the mayors are, they're the ones who actually, they know their villagers, they know which ones are veterans. A lot of the times they already know this, and they know that there are many veterans who just do not want to be recognized as that or answer any of other questions regarding that. So it makes it optional, and so that the mayors can do what they do best and do what the veterans request also. So hopefully, this will just assist your efforts, and I think it could also, the mayors can point out, there's an online registry so that those people in the villages who they speak with can also do that, right? That would also still be available to them. So I want to thank you also for your efforts with the online registry. Thank you, Mr. Chair.
Very good, thank you.
Thank you, Vice Speaker. Any others have any questions for Mr. San Agustin? You have a question? Senator Ada.
I certainly support any effort to collect data on our veterans to get a clearer definition or quantification of how many veterans we have here on island as a basis for the possible demand for services. But in your opinion, for example, CBOC, there's been, everybody talks about we have thousands of veterans. And as a result, we really should have a larger facility up there at CBOC. But it seems that, I guess, the Veterans Administration is basically, the U.S. Federal Administration is basically saying, but based on the number of people that have signed up to use CBOC, it does not justify the larger facility. So in other words, they're going by the number of people that have signed up. When we get numbers from Department of Revenue and Tax as to how many veterans have actually taken advantage of the benefits, the fee waivers and whatnot, it's like 1,000 possibly out of the many thousands that everybody believes there is here on island. And I imagine if I take a look at their intake down at the Veterans Affairs Office, I don't know how many sign up, but I'm sure they're not lining up at the door. But I think that any effort to collect data certainly would help to better bring a clearer definition of just really, or quantification of just how many veterans we do have on island. But otherwise, unfortunately, it seems that the facilities that provide the services, at least the numbers that they register, just is always a lot less. So I don't know, maybe your thoughts on that.
Yeah, thank you. Senator, thank you for that. You know, I hope that you will not give up the fight to pursue the expansion of the community-based outreach clinic. I hope to not give up the fight to pursue a veterans hospital. I hope that, and I know I'm not going to give up the fight to try to find a way to have a veterans home for our aging veterans. The numbers will remain small as long as the center is small. What we're not seeing is the choice card program that is efficiently working as it is designed to. So the way the choice program works is the individual checks into the CBOC or checks into our office. We provide all the information and send it off to the federal VA to find out that the individual now qualifies for a choice card under the choice program, which is one of the most efficient programs that there is based on where we reside here on the island, but it is also found out that it's been very beneficial to the main United States for those folks that have to drive miles and miles away, and that's why they revived it. So as long as the community-based outreach clinic remains small, which I'm understanding that the expansion has been approved and it should be in motion, we must remain vigilant that because there is a program such as Choice that is providing that service to our veterans, where they call the number, once their name is pulled up on the system, it pretty much displays what their medical needs, medical conditions are, and therefore the individual at the other end will refer them as to what clinic is it that they will go to here on our island. While that is good for business outside, what our veterans and our service members are very accustomed to are people that are actually somewhat in uniform. They're used to going to sick bay, they're used to going to clinics and dealing with physicians and nurses, corpsmen that are in uniform. In saying this, I think that we should continue to push that the community-based outreach clinic will continue with their expansion. I think I would ask for your support so that we could continue to push for a centralized VA hospital, at least here in Guam, so that our people from the Micronesian Islands, Saipan, Rota, Tinian, FSM, Palau, will not have to fly to Hawaii like many of our patients here do, will not have to option not to utilize the VA program because in the absence of that service, and they opt to go ahead and fly to the Philippines. I think we should continue to fight to better the health system here in the Pacific so that our patients, our clients, and their family members don't need to fly off island, and to avail those services here. We deserve it, Senator. We deserve to be able to have services rendered here on island instead of waiting for the patient's temperature to go down before we fly them off to Hawaii or LA because we don't have the skill set or the professions that we so deserve. When the service member, regardless of what service they were in, they didn't question why is it that they're being sent off to certain places to serve their country. They were just given orders and they execute. They deserve to be taken care of. And I hope that you're behind me to continue to fight to make it better for them. They're not going away. Thank you, sir.
Any other questions from Mr. Sanagos? Thank you, sir. That will conclude the hearing on Bill 219-34 and take us to our last agenda item, Bill number 292-34, and I'll yield to the author, Senator Dennis Rodriguez, Jr.
Thank you very much, Mr. Chair. Mr. Chair, what this bill does is basically two things. One, it authorizes our boards and commission to, sorry, that's a different way. It authorizes our boards and commission to allow for video teleconferencing at meetings. And also, the second part of this, it allows for live streaming at boards and commission meetings so that the public can have can participate even if they're not there physically. A lot of the boards and commissions now that are not meeting and not getting a lot of their things moved through is because of a lack of quorum. And so by allowing this type of a process to happen, we can perhaps see some sort of efficiency and more of the people's work moving forward if we're allowed to do this and use technology to our advantage. So thank you again for the opportunity to have this heard and look forward to placing this on our session agenda in the next session. Thank you.
Thank you, Senator Rodriguez. We have no individuals who have signed up to testify regarding Bill 292-34. Barring any other statements from my colleagues regarding this bill, we will go ahead and render this bill as being heard in today's hearing. That will exhaust all items on today's agenda. I would like to thank all of my colleagues for joining us today and for participating, and we'll go ahead and adjourn this hearing at 11:58 a.m. Thank you very much.